personal injury law show. This show that talks about everything current in law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got a partner in the law firm, Nuncio Tartaya. Good evening, Nunc.
Tony, viewers, welcome.
And Jess Rosla, public liability insurance lawyer in a law firm. Good evening, Jess.
Evening, Tony. Evening, viewers.
Viewers, tonight we've got an interesting show on the perils of nightlife, so stay tuned.
Before we kick off, Tony, what's in the news?
Nunc, Jess, there's been a lot of stories, but one that's really interesting and it's been sort of hovering for a while is police bullying, Nunc. Tell us a bit about this.
Well, look, there's been an investigation that's been opened, Tony, because of the immense bullying that's occurring and harassment that's occurring in the Victorian Police. And when you look at the stats as to how the extent of it, it's alarming to how much is actually occurring within the police force.
Well, it is a concern to me, Jess, because I'm now part of the Bully Zero board, and our idea is to try and educate and try and stamp out bullying. What do you think is going to come from this?
Well, look, Tony, I think it's a really positive step forward, what they've initiated, particularly getting the Victorian Equal Opportunity and Human Rights Commission on board to bring an element of objectivity into it. So hopefully it means we can, have some equal standards put in place and measured against the bullying investigations. No, it's been a personal injury lawyer, and you've been in this area for some time. It's amazing how many police over the years have approached me to say, look, I've been bullied by my immediate supervisor or the force in general. And for some reason, these matters have really never gone anywhere. What do you think is going to happen this time? Do you think they'll actually take positive action? Look,
I hope they do, and that's, I think, the key objective to this, because a lot of people are just concealing it, they're not coming forward, and it's hard to rectify it if you're not coming forward. And, I think if you look at the stats, Tony, I think 7 suicides in the last 33 months, that's a big number. And look, I really do think this is a step forward. Look, it's no guarantee, unfortunately, but at least they're being proactive about it anyway.
And I guess the sad thing is if people aren't happy with their work, and this is pretty extreme, they won't be doing their job as well as they could otherwise do, correct?
Yeah.
All right, we'll come back to this viewer, so stay tuned on that story. What about this major stress settlement for a teacher? A fellow by the name of Mr. Doulis got 1.3 million, and there's been another case since. Tell us a bit about the facts of this one, Jess.
So Tony, in this case, Mr. Doulis was a teacher at the Werribee Secondary College for, I think it was just over 10 years. 12 years, in fact, and he'd repeatedly reported complaints about being overworked and being given classes where students were consistently underperforming and trouble students, and unfortunately the complaints fell on deaf ears, which over time led him to suffer a psychological injury.
No, this is probably one of the first of its kind because, look, teachers being stressed at work is not new, is it?
No, that's right.
But it's something new in the sense that it is a landmark decision, $1.3 million. It's a lot of money.
Look, that's a big settlement in any terms, Tony. I think it's also a landmark because what the background to this is that Werribee, they sort of segregate their best and worst students. And it seems like the teachers that are struggling are in those classes where they're not the most academically gifted students and they're having trouble with that. And it's a double-edged sword, they're trying to create a different regime at school, but at the same time it's causing the teachers stress. How do you balance that up?
Well, the thing, Jess and Nunc, is how do you look after these so-called bad students?
And the problem is you've got them all in one or two classrooms as opposed to having, a splittering of good and bad students. So it's a difficult one.
And I think the difficulty in this case is that they are getting, their stats up in terms of the high achievers kicking goals. So they think it's working for them and they're getting good results from it, but realistically it's at a cost. So.
Look, my real concern about this case is what do you do with these so-called kids that aren't performing? I don't know what the answer is.
As Jess has rightly said, maybe the school's happy that their overall sort of VCE performance is increasing, so they're prepared to take a hit on, as you said, a few bad eggs, unfortunately.
Well, at what cost? I mean, these kids are going to cause problems into the future, you'd think, and the teachers. I mean, this Mr. Doulis is out of action.
And I'm sure the insurance company doesn't want to keep paying up settlements to teachers.
Well, funny enough, shortly after that, there's been another big settlement, which is now on appeal.
Well, there you go.
All right, let's keep moving. Obstetrician defends a care in a deaf case. Give us the facts of this, Nonce. It's a very sad case.
Yeah, sad case. We've got a death of a young child at birth, and it's before the coroner's court at the moment, from what I understand. And effectively, the obstetrician, it's being alleged that he should have performed a caesarean as opposed to a vaginal birth, and that delay has caused the death of the child. And it's still ongoing, but unfortunately, it looks like there's some weight of opinion that's against this obstetrician in this case. Just
interestingly, on this case, Jess, there's about 4 or 5 obstetricians being critical of the doctor in question.
Yeah, that's right.
And I guess the test in our Wrongs Act is what? The weight of opinion.
That's correct, yeah. Whether the doctor acted in accordance with competent professional practice, which is consistent with what their peers consider that to mean. So certainly in this case, the evidence, I guess, demonstrates that there were alarm bells that should have gone off to the doctor 5 hours prior to performing the caesarean or making the recommendation for the mum to have the vaginal birth, and that was disregarded. Whereas the doctor has maintained that even in hindsight, he would have performed or acted in the same way. So it's going to be interesting to see how it plays out, Tony.
Jess, the doctor's going to have to say he wouldn't have done anything differently, wouldn't he?
Well, that's what he's alleging, but unfortunately, I think, as you said, if you've got 4 or 5, the weight of opinion seems to be against him. And look, unfortunately, also there seems to be, I think, earlier on an abnormal CTG, which indicated some fetal stress, and I would have thought that was a fairly strong sign that maybe the vaginal birth wasn't the correct one. But look, I'm no doctor.
But Nonce, the thing about it is that everything was pointing to problems with this case.
Yeah.
She was a very large woman to start with. She had complications with blood pressure and obviously other things.
Yeah.
Anyway, look, we'll keep you posted on this case because it's still before the courts. Viewers, we've got to go to a sponsors break. Stay tuned. After a break, we're going to discuss the perils of nightlife. Welcome back to the show. We're going to talk to you about the perils of nightlife. Now, what that means is there's a lot of pubs, clubs and those sorts of locations where a lot happens in Victoria and anywhere and everywhere in Australia. The first case, which wasn't the best for injured plaintiffs, was a case of Adil's Palace and Mubarak. It's a 2009 High Court decision. Let's give us the basic facts of this case.
Tony, this was a case that was based in 2003 at a party in New Year's Eve in Sydney. A fight arose between 2 female patrons. Then at the time, a bigger sort of brawl erupted, and one particular patron, he went, I think he was a partner of one of the girlfriends, he went home, got a shotgun from home, came back, he shot one patron in the leg and then also shot another patron in the stomach who assaulted him when the fight first erupted, and that's the basis of this case, Tony.
Jess, this is a real bizarre set of facts. You've got people that punch on, someone gets hit, he says, I'm going to come and get you. So he goes home, gets a gun and comes back and cuts loose.
That's right, Tony, and I think the point you make there is really relevant. He had the intention to come back and get revenge effectively, and the court did assess that in working out whether the occupier in this case could have prevented someone who had that intention, which was relevant in deciding that despite however many security guards were there, it wouldn't have prevented him coming back.
In the first instance, the plaintiff won.
Yeah.
In the New South Wales Court of Appeal.
Yeah, that's correct.
Sorry, New South Wales
Supreme
Court, then the Court of Appeal. But this is not the criminal case we're looking at. This is a civil case.
That's right.
Adil's Palace, which is the location where it occurred, then gets special leave to appeal to the High Court. What happens there?
Well, basically the High Court said that despite how many security you had at the time, they don't believe that would have avoided this accident effectively. They're saying that there's a legal element called causation that they could not sustain, and basically saying that doesn't matter how much security you had, he came with a gun, you're not going to stop that.
Well,
which I can understand, Tony.
In fact, the High Court said that we're not even going to go to the issue of where there's been a breach. They don't even get past duty.
Yeah.
They say, what sort of duty can you impose on a Dills Palace when you got someone with a gun?
That's right, but look, if you came back and, there was more of a fist fight as opposed to anything with, guns and knives, this could have been a different argument or a different outcome because, you can arguably prevent that, but, when you got guns involved, it's, you can't stop a madman, unfortunately.
Well, looking at what happened in the High Court in this case, you'd think that no one's got any opportunity of winning. But that's not necessarily the case because the next few cases show us that you can proceed and win in these circumstances. And on that note, tell us the facts of Kingi-Rihari and Maffia Proprietary Limited, 2012 New South Wales Court of Appeal decision, Jess.
Yeah, so Tony, in this case, it's a little bit different. It's not really an assault case, it's more of a slip and fall. So the plaintiff in this case was out for drinks with a couple of workmates and he, unfortunately, as he was walking, slipped and fell on what he alleged was a wet floor. The occupier and the licensee in this case both agreed that they owed him a duty to make sure the area was safe. And the real question was whether the floor had been, mopped adequately or cleaned up adequately.
Nods, the plaintiff in this case injured his right knee.
Yeah.
Pretty badly.
Yep.
Affected his capacity to work and, enjoy life, etc.
Yep.
What happened with the court in the first instance?
Well, Tony, he was successful. They found that the defendants were liable for the injuries that were sustained to the plaintiff, and effectively they found that it hadn't been adequately mopped, and also if it had not been, there wasn't a wet floor sign up. So they're saying that effectively materially contributed to this accident, and he was awarded damages in that regard.
Jess, so this case just turned on the fact, was the floor wet or not?
Yeah, that's right.
Pretty basic proposition, isn't it?
Yeah, it was. And also looking at the defendant's own policy and whether they'd complied with it. And the facts showed that although the area had been mopped prior to, it hadn't been mopped to dry the area completely. And further to that, a wet floor sign wasn't in place, which would have been mitigating circumstances.
Just curiously, what did they rely upon to come to the conclusion that the floor was wet?
Look, Tony, in all these cases, there would have been a range of things they relied upon. So it would have been the testimony of the plaintiff. I'm sure there would have been evidence of the defendant. They would have been asked under oath as to whether, had been mopped and when it had been mopped. And I'm sure that kind of evidence then all led to the conclusion that, it was wet. And what did they do in response to that? And obviously not enough.
Well, Jess, what I find extraordinary is they knocked off 8%, not 10, not 5, 10 or 15 or 20, but 8% for contributory negligence.
Yeah.
Viewers, what that means is that they said the plaintiff was 8% to blame for his injuries. How did they come to that conclusion?
It is a very precise percentage. I did think the same thing when I was reading it, Tony. But ultimately the basic proposition was that the court is assessing that every individual has a responsibility to look where they're going and ultimately concluded that 8% was the right number. So.
Tony, you've been practicing for 30 years. Have you ever seen 8%?
No. Look, what I normally find is that juries and courts take off round numbers, 5, 10, 15, 20, sometimes 30. I've seen them knock off 60.
Yeah.
But 8% is a very unusual number. Must be someone's favourite number, who knows?
What was interesting in this case, though, I think that's important for other cases, that this particular plaintiff, the facts were that I think he was at the time of the accident was working as a scaffolder, but then his evidence was that he was going to work in the mines. And there was no, he'd only had some online sort of research into it as opposed to any, firm job positions or offers, and they still found for him that he would work there for at least 5 years, which I think was a good outcome for the plaintiff.
Well, just as well this occurred then and not now, because the mining boom's just about over. And there's been 44,000 jobs lost this year in the mining industry alone. So that argument wouldn't have held up.
Would have gotten a bit of money though.
Yeah, at the time.
Yeah.
But if it had happened now, there's no way the court would have accepted that argument.
Yep.
Because so many people have lost work in the mining industry. Look, let's get on to this interesting case that you ran, Nuns. Matter of Lisa Herod. She was awarded over $1 million, but didn't get that because there's all sorts of issues.
Yep.
Give us the basic facts, because we'll have to get a break.
Yeah, Miss Herod was at the Carlton Club, which is a prominent CBD bar, and she was there with friends and just having a good time. And while she was on a corner of the dance floor, a group of her friends just put her bags in the middle on the side. As she bent over just to get something out of her bag, there was sort of spiky bits that were pointing out of a planter box, and I got one, I think her left eye, and unfortunately she lost her whole sight in that eye, Tony, and look, disastrous outcome for her, and hence why we issued a claim against the Carlton Club.
And Jess, what happened here was artificial pot plant, something sharp protruding, just pricked her in the eye.
Yeah.
And that led to a chain of events that then she lost her sight. Viewers, stay tuned. We've got to go to a sponsors break. After the break, we'll tell you what happened with this case. Welcome back to the show. Before the break, we were talking about the unfortunate Louisa Herod. Now, Nuns, this sad case, the jury were very sympathetic to her cause, although it was bitterly contested in court. How long did the matter run for? Oh, look, the matter ran for around, I think, 10 days in total, and it was a case that was around for a couple of years, Tony, and said it couldn't resolve via negotiation, which we thought it could. Never did, and had to go all the way to a jury, and ultimately, Louisa got the verdict that she deserved. And she was awarded $1 million initially. But the judge then brought it back to the statutory max. Yeah, so effectively, it was only really a pain and suffering claim, Tony. So she hasn't really lost any income. It's not going to affect her future prospects. So effectively, the claim comprised of her pain and suffering, which, as you said, in Victoria, the stat max is at 500 grand. The jury obviously weren't aware of that, and they're not meant to, and they awarded her $1 million, but unfortunately that doesn't all go in her pocket, and it had to be drawn back to 500,000. Well, what happened then once the stat max was under 500, but they awarded some future medical treatment, then they rounded up to $500,000, viewers. Just interesting, Jess, immediately prior to the incident, the dance floor was crowded, forcing the plaintiff against the foliage of the pot plants. The incident was caused by the negligence or breach of duty of the defendant. Now, the club really argued, they contested it heavily, that we've never had this incident before in our history. And we've had thousands of patrons coming through our doors. How relevant is that?
Well, look, Tony, I guess it's relevant for a jury's perspective to consider. I mean, what are the chances of this occurring, and was it reasonably foreseeable, which is a factor when determining negligence. But the way the facts are pled and the way it occurred was that it was foreseeable, that if there were that many people and you were pushed up against the pot plant in this case, that it could occur. And
Nance, just as easily as she won the case, the jury could have come back and said, well, it was just an unfortunate accident, correct? Look,
they could have believed the defendant when they said, we've had a great history and this has never occurred, and they said, well, it's a freak accident. But look, I've never bought that argument, Tony. I don't care if it happens once or 100 times. The fact of the matter is that, as Jess said, it was reasonably foreseeable. Anybody could happen to anybody, and and unfortunately, she copped the consequences.
Let's hope Louise is doing well out there. Let's keep moving. There was another interesting case of Moon, Broadbeach and Lambie. What are the facts of this case? 2014 decision. Yeah,
quite recent, Tony. So in this instance, the plaintiff was attending a work Christmas party at the Moon Broadbeach, a club at the time, and one of his friends had been asked to leave. My understanding is that there was a fight that had broken out outside on their way out, and somehow the plaintiff, although his memory was affected from the incident, couldn't recall, but somehow got involved in the incident, and one of the employees, who wasn't a security guard, came out and attacked the plaintiff with a metal rubbish collector, causing him serious injuries. I think the key question that the court had to look at was whether the employer was vicariously liable for the employee's actions in circumstances where they had intentionally assaulted somebody.
Just on that, viewers, vicarious liability means that the employer assumes the liability of the person that caused the damage. Now, Nuance, what happened with this case?
Well, effectively, the plaintiff succeeded, Tony, and they found that the employer was vicariously liable and thus liable for the injuries it sustained to the plaintiff. And I think the issues that arose in this case was that, you know, when you've got a club or a bar, whatever you want to call it, you've got, you know, high alcohol on site, and also the fact that you need to be quick in your response. He didn't have time to get security guards, so he just looked, you know, on his own accord, went out there and tried to stop the fight. But unfortunately, the plaintiff suffered injury in the meantime. It
just goes to show you the high duty on these clubs when you've got liquor.
Yeah.
You know, the appropriate consumption of alcohol and service of alcohol is so critical, isn't it?
Yeah.
And usually it is triggered by people that have been drinking too much, more often than not.
Yeah.
An interesting one. Do you think, though, the employer would have been upset by the employee's actions to try and stop the fight when he's not security, hasn't been trained in it?
I wouldn't be surprised if this particular person doesn't have a job in that place. This is something that we don't know, but I would have thought that his employment would have been very tenuous.
Look, he was acting in the right interest, but unfortunately he just went off his own accord.
Exactly. A bouncer assaulted a patron and awarded $168,000. What affects of this case? Nicole and Dobson notes. 2014 New South Wales again.
Just in short, it goes for a while, but in short, Mr. Dobson grabbed another patron at an RSL, and this patron complained to security. He was approached by security and asked to leave. At that time, Mr. Dobson and his friend, they obviously were largely intoxicated and were verbally...
They were groping.
Verbally assaulting, and because she was a female security guard, escorted them outside, and then they came back, and because I think there was an RSL courtesy bus that was leaving, and they tried to get on, and I think the rule was once you're been kicked out, you're not allowed to get on the courtesy bus, but they tried to get back on. Once again, they, I think there was groping, verbal assaults and the like, and eventually, Mr. Dobson and his friend left, but that's the cause of action against a range of individuals and clubs.
And what happened here, Jess?
So in this case, Tony, proceedings were brought against the club, the security company, and the two individuals personally, and ultimately the court found that the club wasn't viable, the security company was, and as were the two gentlemen involved in this case.
And damages were awarded of approximately $168,000.
That's correct.
The difficult part was that the majority of the settlement or the compensation was against the two individuals, and, you know, what's the chance of getting some money out of them, Tony?
Yeah, it'd be pretty tough. So, but anyway, just quickly, a man was attacked by a bouncer, awarded $1.8 million in the case of Dixon, Chafee and Redorn. 2012 New South Wales again. Yeah,
I'll be very quick, Tony, but basically this is similar to the last case. A father was I think innocuously leant back on a security guard's car. The alarm went off. Security guard reaction was just ridiculous. I think he elbowed him to the temple. He fell back on his head. Anyway, a case was issued against him, and I think there was damages award of, is it
just under $2 million?
Yeah, $1.3 million. Against this individual, though, so the chances of getting money is... there's two reasons why he won't get money now, Tony, unfortunately. One, the plaintiff has passed, and two, being an individual, we never get the top of money.
It's very sad, isn't it? Anyway, Jess, thanks for coming on board.
Thanks for having me, Tony.
Thanks for coming on board.
Thanks, Tony.
Viewers, thanks for watching. Stay tuned for future episodes, but before that, go to our website, YouTube, Twitter, and all those other fancy social media accounts that we've got. And stay tuned for future episodes, and always remember to stay safe.